My name is my name is Zaida Maldonado Prader, and I am a member of the Indiana group to include coalition. Our organization and sponsors are very excited for your attendance to the first three webinars that we will be featuring during this month, October, known as the National Disability Employment Awareness Month. For more information about our organization and coming webinars, we can be found at www.worktoinclude.org. For the purpose of knowing better today our audience, we will appreciate if you can indicate the title that best represents you in the chat room. The categories are employer, individual with disability, family member or guardian, employment provider, educator, or other. Now, on behalf of Work to Include, I am glad to introduce our speaker, Brien Shoemaker. Good morning, Brien.
Good morning. Thank you, Zaida. I appreciate that. Oh, go ahead. I'm sorry. I didn't mean to interrupt.
So Brien is the Outreach and Education Coordinator for the Indianapolis District of the U.S. Equal Employment Opportunity Commission, also known as the EEOC. Since joining the EEOC in 2001, he has served as an investigator and supervisor. As an investigator, Brien earned the Commission's Core Award for outstanding contributions to the EEOC for his work as the lead investigation in a multi-agency class case involving hiring discrimination. As an outreach and education coordinator, Brien earned the Circle of Excellence Team Award for his contributions to the National Training Program for New Investigators and for his work with the historically Black and colleges and universities. Brien is also a member of the Labor Trafficking Committee for the Indiana Protection for Abused and Trafficked Humans and has spoken on this topic to numerous groups. So now, without further delay, we have here with us today, Brien Shoemaker.
Thank you, Zaida. I appreciate that. I'm going to pin myself here so that I think everybody will be able to see me. And then I'm going to kind of go move my kind of notes around here. All right, so I appreciate everyone being here, and it's nice. I was looking at a few comments, so I see a lot of educators, I see a lot of advocates. That's wonderful. Today, I'd like to talk a little bit about the Americans with Disabilities Act, and I'll be coming from it from a couple different perspectives. So what I'd really like is, my program is going to be touching on all sorts of things, primarily reasonable accommodations, because I think that's where most people have questions. But I would love it if you just go ahead and put your questions in the chat. And that way, I think Zaida's going to be there, Patricia's going to be there, and they'll be able to ask me those questions. So if you have questions, please go ahead and put them in the chat at any time. And then either Zaida or Pat will go ahead and ask me those questions at the appropriate time. So, so thank you for doing that. Again, my name is Brien Shoemaker. I'm with the Equal Employment Opportunity Commission. I have some of my information here. So in case you want to reach out to me at any time, you certainly can. I'm more than happy to speak to you about the EEOC laws and some of the activities and trainings that we do. And that's my contact information. I want to start off before we get to reasonable accommodations in the Americans with Disabilities Act. I want to just touch on who is the EEOC? What do we do? What is our function? And what laws do we cover? So I'm going to touch on that just so that we're all on the same page when we start thinking about the Americans with Disabilities Act and what the EEOC does. So the EEOC was created by Congress with the passage of the Civil Rights Act of 1964. We opened our doors in 1965, and we deal with employment discrimination. That's what we look at, okay? We're an independent federal agency. We have offices all over the country. The office that I work out of, the Indianapolis district, includes Indiana, Michigan, Kentucky, and then half of Ohio. Okay, and that's the district that I kind of work out of, but we are a federal agency so that we are, of course, across the United States. Again, what we do is resolve cases of employment discrimination. And that's going to be key when you start thinking about, reasonable accommodations and discrimination. What does that mean? Well, it means employment discrimination. And so I thought it would be a nice way to kind of think about what the EEOC does by looking at the laws that we enforce. So we enforce the Equal Pay Act, the Civil Rights Act of 1964, Age Discrimination and Employment Act, Americans with Disabilities Act, the Rehabilitation Act, Civil Rights Act, Genetic Information Non-Discrimination Act, Americans with Disabilities Act as amended in 2008, and then the Lilly Ledbetter Fair Pay Act, 2009. Now, that's a lot. Okay, but just knowing the names of those laws sometimes isn't very helpful in determining what we actually do or what the laws actually do. You might be able to figure out, what the Americans with Disabilities Act is, okay, because it's kind of right there in the name. But what exactly is the Civil Rights Act? Who does that protect? All right, we're not sure just by looking at the name. So I think a better way to understand what the EEOC does is by breaking it all down and saying, all those laws, if you put them together, what are they doing as far as labor is concerned? And we look at protected bases. Okay, so there are protected bases that are involved with those laws, and it says is unlawful to discriminate in employment based on those protected bases. And what are those protected bases? Whether age, color, disability, genetic information, religion, national origin, sex, which includes pregnancy, and age 40 and older. So that's really what we're looking for. If you feel that you're being discriminated against in employment because of one of those protected bases, then that would be covered under the that would be covered under the EEOC, and we could look into that charge for you. Okay. So what we're going to focus on today is the ADA, the Americans with Disabilities Act, and we're going to focus on reasonable accommodations. And like I said, we're going to focus on reasonable accommodations primarily because I think that is where most people get confused. It's where we kind of differ from some of the other laws that we looked at. The mandate to provide a reasonable accommodation is a little bit different. And so sometimes it can get confusing. So I want to focus on reasonable accommodations today. But we will be talking about harassment a little bit at the end. And we're going to first talk about asking the correct question when we think about the Americans with Disabilities Act. And what is that correct question? Okay, all too often, employers, individuals, advocacy groups, when they hear about an incident that occurred and they think that there may be discrimination based on a disability, the first thing that they think about is, does this person have a disability? Okay, let's look and see and determine whether or not this person is actually disabled under the law. Does this person have a disability? But I think that is the wrong question to ask first, okay? Because it kind of distracts us from what is the real issue. And the real issue is, was this person treated differently? Okay. Could this person be accommodated? Okay, was there an accommodation for this person? Can I accommodate this person? Was this person harassed? Okay, those are the questions that you should be asking. Those are the correct questions to ask first. And the reason that is we'll see in a little bit why the definition of a disability should be expected to be broad. Okay, so it's going to include a lot of people. But asking the question, was this person treated differently, puts us in the right mindset. Okay, it makes us as employers, if we're an employer and we're looking at this and we're saying, was this person treated differently? We can then see, okay, maybe there are issues within my company that I need to look at. Okay, was this treatment different because of a policy? Okay, is this person being treated differently? Are there policies in place that are treating this person differently? Okay, maybe there's some issues and some personality conflicts that I need to work out. Even if the answer is this person wasn't being treated differently because of their disability, they still had a concern and they still came to you as an employer. And now it behooves you to look at that complaint. Maybe there are issues within the company that you need to check on. It's an opportunity for you as an employer to go, hey, let's review the effectiveness of the work, of my work environment, our work policy, the work procedures that we might have, because if things are not being communicated well, people might feel that they're being treated differently. All right. So this is a good opportunity to look at that situation. All right. And by not asking whether this person has a disability, so all your focus is on whether or not there's a disability involved, you're missing the big picture. This person is coming to you with a complaint. Okay. They feel that they're being treated differently. And it may be because of their disability. If you're an advocacy group, or if you're a person that's working with people with disabilities, the question, was this person treated differently, is a really good one to ask. You can get some good information about that. You can get some information about the situation. You may be able to come up with ways that can resolve the situation, okay, and be able to present that to the employer or present that to the employee so that they can work on the issues that are happening within their employment. Again, by focusing just on whether this person has a disability, you're missing maybe a bigger work picture or a work problem that may be going on. And so we want to work on that. Okay, so asking the correct question is so key in these, especially with ADA cases, because we want to get away from just focusing on the disability. The disability is the only thing that we see and the only thing that we care about. We want to know the big picture. We want to know what's going on, and are there ways to resolve the situation? So let's get into Title I of the ADA. Now, I say Title I because the Americans with Disabilities Act was a huge law. There's lots and lots of aspects of everyday life that is included in the Americans with Disabilities Act. Title I specifically talks about employment, okay? And so Title I kind of lays it out for us and says that an employer cannot discriminate in any aspect of employment against an individual with a disability who is qualified. Okay, so let's break that down so we kind of get an idea or a feeling of what we're all talking about here. So the first thing, any aspect of employment. This is so key because a lot of times, reasonable accommodations is the first thing that we think about when we think about ADA. We often forget that, someone with a disability can be discriminated in other ways. All right. So we're talking about discrimination, treating people differently in the hiring and firing process. When we're talking about compensation, assignment, job classification, transfers, layoffs, anything like that, that is all an aspect of employment. It also includes things like the application process or recruitment. Okay. It can maybe even include things that happen after the person leaves, if there's some sort of retaliation, if a company is giving bad employment references because of that person's disability, okay, or in retaliation for something that occurred, an EEO, event that occurred while the person was employed at the first company. So we want to talk about all aspects of employment. It's not just reasonable accommodations that the ADA deals with. It's all aspects of employment. So that's the first part of, the definition that we're going to take a look at today. And then we're going to focus next on an individual with a disability. So we are going to define that. We are going to take a look at what does that mean, okay, under the law. And then we're going to look at what does qualified mean? Why do they put that in there? In that definition. We're going to take a look at that today too. Again, our focus today is going to be on reasonable accommodations only because I think that's where most people have questions. So I want to be able to answer those questions. The ADA does include a requirement, and this is important, that the employer must provide a reasonable accommodation to a person with a physical or mental limitation. Okay, so that is included in Title I of the ADA, that the employer must provide an accommodation if there is one to provide. And we'll get a little bit into that a little bit later. So let's talk about the definition. I know that the questions that we're supposed to ask is not whether this person has a disability, but I still think it's important for us to understand what that means, okay, so that we're all on the same page. So the ADA does a three-pronged definition of disability. We're going to talk about the first prong, which is physical or mental impairment that substantially limits a major life activity. That's the prong we're going to focus on today, okay? But it could also include a record of an impairment, okay? So someone who has a past history of a disability, all right? And an action is taken because of that past history, or they could be regarded as, okay? The person may not actually have a disability, but the company regards them as having a disability or a physical or mental impairment that substantially limits a major life activity. Okay, so those are the three definitions. We're going to focus today on the first one, a physical or mental impairment that substantially limits a major life activity. And that is a lot of words. What do those words mean? Well, let's first start about this impairment idea. All right, this physical or mental impairment. All right, so it could be a physical impairment or a mental impairment. Sometimes people think of these things as obvious disabilities when we think about the physical impairments of a physical condition or disorder, physiological condition or disorder, versus a hidden disability. All right. And sometimes the mental impairments are considered hidden disabilities because they're not outwardly obvious. Okay. So it could be a mental or a psychological disorder or condition. All right. And when we think about these impairments, either physical or mental, we're going to think about them and how they affect a major life activity as compared to most people in the general population. All right. So it's a physical or mental impairment that affects a major life activity. Well, what the heck is a major life activity? What are we talking about here? Major life activities actually are a lot of different things that happen that you do probably every day. Okay, I've listed a few. This isn't all of them. I've listed a few, probably the ones that we think of most often when we think of major life activities. Those are things like lifting, reaching, caring for oneself, okay, hearing, seeing, eating, walking, bending. These types of activities are major life activities. So if you have a physical or mental impairment that's going to substantially limit one of these things, then you could be covered under the Americans with Disabilities Act. I think it's important to note too that some of the major life activities we often don't think about, but they are still included here when we think about it in totality. So concentration, thinking, okay, learning. These are some major life activities that we may not think of right away. We often think about, the lifting, the bending, the walking, those types of things. But reading, learning, concentrating, thinking, these are also major life activities. So if someone's substantially limited as compared to the general population, they could be covered under the Americans with Disabilities Act as well. All right. Oftentimes, the learning, reading, concentration, thinking, these are part of the mental impairments that we associate with under this definition, okay? But it doesn't stop there, okay? Major life activities also include major bodily functions. And so we're talking about functions of the body, the immune system, things like the circulatory system. If we were to say somebody was substantially limited in their ability to regulate their cell growth, what are we talking about? We're talking about cancer now. All right. So now suddenly these diseases and some of these other conditions that people may have that affect bodily functions are now going to be put under the category of being disabled. Okay. Major life activities. So it's something to keep in mind as well. And you can start to think and see now why, that definition of the question to ask is not whether this person has a disability, okay, or is this person disabled? It's, what's the issue? What's the problem? Was this person treated differently? Because suddenly now we can see that, we are really having some broad coverage. The definition of disability is expansive, okay? And that is one of the things that Congress did in 2008 is they amended the ADA in part to be more expansive. Okay, and it gave us a little bit of a guideline here, with the 9 rules of construction They gave us some guidelines, which is really nice when we're talking about substantial limits. So what does that mean, right? We know what a major life activity is. We know what an impairment, a physical and mental impairment is. We kind of talked about that. But what about the substantial limits parts when we're talking about the general population? Well, thank goodness we have some, rules here that we can look at. And the first thing I wanted to highlight was this issue of substantial limitations shall be construed broadly and in favor of expansive coverage. Okay. And again, we have here extensive analysis is not required. The primary focus should be on the person's qualifications for a job, need for a reasonable accommodation, or whether discrimination occurred. Those are asking the right question. Can I accommodate this individual? Okay, was this person treated differently? Was this person harassed? Okay, these are the questions that we should be asking and not focus on whether or not this person has a disability, because honestly, we're looking at that in broad and expansive coverage. So that is why asking those right questions, asking the correct question is the first thing that we should be thinking about. Okay. And then I did want to point this out as well. This is a really good thing to think about, because if you, like me, started your career in, looking at the ADA before 2008, oftentimes we would ask the question, well, how long is this impairment going to last? Okay, because that was important for us. But now it's important to understand that there's no minimum duration. So even if an impairment lasts less than 6 months, it could still be substantially limiting. Okay, so that's important to understand. You can still be covered under the Americans with Disabilities Act if your impairment that substantially limits a major life activity lasts less than 6 months. Okay, and that what that means is you may need an accommodation. Okay, you're entitled to an accommodation if you're covered under the Americans with Disabilities Act and need that to perform the essential functions of the job. So that's something to keep in mind. Okay, so good. So we kind of have this, we have this definition, the first prong of the ADA in our head now, a physical or a mental impairment that substantially limits a major life activity. We get a feeling for what that is, okay, expansive, broad coverage. So now let's think about this second section, which is an individual with a disability. We know what that is, okay, who is qualified. All right, so what does qualified mean then? All right, we're going to break that down. And really what it is just what you would think, right? Does this person have the skill necessary, the experience, whether that be education or maybe license or whatever else qualification standards that person needs for that job? Can they satisfy the qualifications of that job? Are they qualified for that job because they have the skill, the experience, the licenses, or whatever other skills that are and abilities that are needed for that particular position? Okay, so that's the first thing that we look at. Are they qualified in that regard? The second thing is, can they perform the essential functions of that job with or without a reasonable accommodation? Okay, so that's important to understand, that if you have, if you have a disability and maybe you do need an accommodation to perform the essential functions of the job, then you're still qualified for that job. Okay, you can still do that job with or without a reasonable accommodation. So if you can do it with a reasonable accommodation, you're qualified. If you can do it without a reasonable accommodation, you're still qualified, right? As long as you have the requisite skill, experience, education, and other job-related requirements. So that's really important when we think about it, because you have to be an individual with a disability, and you have to be qualified for that particular job, all right, to have this coverage under the Americans with Disabilities Act. So the next thing to think about, and I think this is really good to think about as far as advocacy groups and individuals as well as employers, is this idea of what is an essential function. Okay, it's listed there in the definition. It must mean something. So what is it? What can we think about an essential function when I'm dealing with an issue with a person with a disability, or I have a disability myself and I need to know what the essential functions are, or if I'm an employer, I certainly need to know the essential functions of the job if I'm an employer. So what does that mean? Essential, all right? And really, an essential functions of the job are the fundamental job duties of that position. you can think of it this way. If you fail to do this particular function of the job, then the job wouldn't get done. Okay, you would fail to do the job in itself. Okay, so this particular function is absolutely important to be able to do in order to be able to do the job. All right. One of the things that I think it's really important to do is to focus on what is the result that needs to be accomplished, not necessarily how you accomplish it. Okay. And this is really, I think, important for advocacy groups and employers and individuals with disabilities, because we want to think about this in a way when we think about accommodations. So I'll give you an example. You may have a job function, okay? And that job function may be, you need to get this box from this department to this other department, okay? And so there may be, the employer may say, okay, well, those boxes are routinely, 75 pounds. And so you have to be able to lift 75 pounds. That is an essential function of the job because the box is 75 pounds, okay? What I want people to think about instead is not, okay, do you actually need to, in order to get the box from one department to the other, do you need to carry it? Or can you use a tool or device, a cart, or one of those motorized lifts to be able to drag that or move that box from one part to the other? Because if you can use something like that, then lifting would not necessarily be the essential function of the job. All you need to be able to do is just move it from one area to another area. Okay. And that's what accommodations are all about. How can we, perform this job function, all right, in different ways? Because what we're looking for is the result. What is accomplished by using this? Okay, by doing this job function. What's the accomplishment? What needs to be done to perform and get the result that is needed? Okay. Another way to look at this is, what does the employee actually require to perform? Okay. If it's a marginal function, they may only do it occasionally. And if it's a marginal function, then as a reasonable accommodation, you can get rid of that. Okay. You can't get rid of essential functions of the job, but you could get rid of marginals in order to accommodate somebody if need be. And thinking about what's the consequences if you don't perform this particular function. If you don't perform this function, does the job not get done? Okay, that then may lead to it being actually an essential function of the job. And one of the reasons I bring this up in particular is if we have any employers here, and even if you're an employee, what's really interesting is sometimes you'll get these job descriptions and say, here are the essential functions of your job. And that job description wasn't updated since the 90s. Okay. And a lot has changed since that time. Probably a lot has changed in your actual job function itself. It probably looks a lot different. And so you want to be aware that if you're somebody with a disability and you're looking to say, what are the essential functions of the job? If you're an advocacy group and you're saying, how can I, help this individual with, their job duties, making sure that you know what is actually performed on that job and not some job description that was written, 20 years ago is really, really important. And employers really need to be able to kind of update those job descriptions. Make sure that job description meets what that person actually has to do. Could be because you'll be using it when you're trying to figure out what's the job, essential function of the job in order to accommodate that individual. So what we really need to be doing is we need to be asking the correct question again. The correct question is not, does this person have a disability, but can this person be accommodated? So if if a person comes to you as an employer and says, hey, I need a reasonable accommodation, your first thought shouldn't be, I know it often is, but your first thought shouldn't be, well, does this person actually have a disability? Let's look at what this disability is. Let's attack this disability. Instead, the thought process should be, can I accommodate this person? Is this person able to be accommodated? And so let's talk now about reasonable accommodations. And so reasonable accommodations are basically just a change in the way that in the work environment, okay, to be able to have a person that needs that accommodation to be able to work, okay? They should be able to enjoy all aspects and equal opportunities of that employment. Oftentimes we think of a reasonable accommodation as a device, okay, as a tool. And sometimes we think of it as a change of work environment. That's all, probably the first thought process that we have when it comes to reasonable accommodations. But I also want you to think about reasonable accommodations should also be exceptions to policy or procedure. All right. So if someone needs to come in a little bit later, I know the policy says that you need to be here at 9 o'clock, you need to clock in at 9 o'clock, but this person needs to clock in at 10 due to their as a reasonable accommodation. Okay, that should be considered as a reasonable accommodation, moving of that person's time. So maybe they work instead 9 to 5, they work 10 to 6. All right. Is the job function still getting done? Or all their work still getting done? Okay, remember, that's what we're looking at, not whether or not, how the work is done. So something to consider. Leave is always a good, is something we should definitely be considering when we're thinking about reasonable accommodations. It's an exception. It can be an exception to a policy or practice. It's important to remember. Okay, it's important to remember. The law requires that the employer provide a reasonable accommodation to an employee or job applicant with a disability. Okay, so it is a requirement. If you need an accommodation to fill out the job application, okay, it is required that they provide you one. Okay, so it's all aspects of employment. It's not just when you're an employee do you get a reasonable accommodation. It's in the application process as well. So something to really consider. And an employer cannot deny employment opportunity to an individual because they need a reasonable accommodation. All right. So an employer can't say, oh man, you need a reasonable accommodation. Well, then we're going to look for somebody else then. That's too difficult for us. Okay. Again, ask the right questions. Can this person be accommodated? Not, does this person have a disability? So what I thought I'd do is, I'll open it up to, Saida, do we have any questions yet? I'm going to take that as a no. Okay. Okay. So again, feel free to ask questions if you need to. All right. What I thought I would do is go ahead and provide some examples of reasonable accommodations, just to give you an idea of what reasonable accommodations can be. Now, this is not a full and complete list by any means. Okay. It's just some things that we see most often and some things that you may want to think about or consider. One of the best ways to really think about this issue of reasonable accommodations is by talking to the experts. And there's probably a lot of experts right now in this room. All right. There's many people that I would suggest that if you're thinking about, man, I don't know if, what accommodation is going to be available to me. One of the best ways to do that is by contacting the Job Accommodation Network. I think probably most people are familiar with the Job Accommodation Network. They're excellent. You have Indiana Disability Rights. There's probably many local advocacy groups that are there too that you can contact. Indiana Crossroads, Easter Seals Crossroads is another example. And so by contacting and making contacts within these other organizations, even specifically with advocacy groups, if you're a business, that's really helpful, because then you can say, man, I just had somebody ask for a reasonable accommodation. I'm not sure how to accommodate this person, but you know what? I do know somebody over at Indiana Disability Rights. Let me give them a call. Okay. Or, hey, let me just contact Jan or Crossroads and see if they have any information for me. That's really, really helpful, because what we don't want to have happen is have an employer say, oh, you know what? I don't know. I can't think of any accommodations, so I guess we just can't accommodate you. Sorry, you're not qualified, right? There's no accommodation out there for you, so you're no longer qualified for this job. We don't want that, okay? Because someone can't think outside the box, or maybe they didn't look hard enough, or they just weren't aware of the many accommodations for people with disabilities. So I always encourage people, employers especially, but also people with disabilities. There are many, avenues for you to find out about disabilities. So here are some of the ones that some examples. We've got physical modifications. Those are the ones we think about most often, maybe moving the the work environment around so that it is able to accommodate your limitations. Things like a sign language interpreter or readers. Those are all, great accommodations. Assistive technology. These are those tools and devices that I was talking about. There's so many great ones out there that it really is. I always learn about something new whenever I talk to, my partners in advocacy with disability rights, and it's always fascinating to see how many really cool technological devices there are out there. So that's a great example. Modified work schedules, right? So maybe this person needs to come in at a different time. Maybe they need to take certain breaks during the day for whatever reason, but they're modifying the work schedule. Is that, against company policy? Well, maybe, but the whole point of a reasonable accommodation is that it can be an exception, right, to a policy or procedure, right? That's what an accommodation is. It's an exception. And so, yeah, you might be, oh, well, that might violate company policy. Well, that's what a reasonable accommodation is, okay? Allowing those types of things, making exceptions to policies, okay? Job restructuring. Maybe there are some marginal functions that are there. So we can move those marginal functions around, move them out. All right. You can't move essential functions, but you can move around or eliminate marginal functions. That's why it's so important that as an employer, you know what the essential functions of the job are and what the marginal functions of the job are. As an employee, you know what your essential functions are and what maybe some of the marginal functions are. All right. You have that in your mind and you can tell people what is the difference. Changing supervisory methods. Now, we're not talking about changing supervisors, but maybe changing the way a supervisor may interact with an employee, right? That may be an accommodation. That's an example of a reasonable accommodation. Having a job coach, those are great accommodations that are very, very successful. Teleworking, we know now that teleworking certainly, I think, is an option that we may not have thought about in the past, but certainly we can see that it can work. And again, should be considered as a reasonable accommodation. Leave, I know this one, oftentimes, employers do not like this, the thought of leave as an accommodation, but it should be considered. Okay, if a person needs some extra time, then that should be considered as a reasonable accommodation. Now, we're not talking about indefinite periods of time, okay, but it should be certainly considered as a reasonable accommodation. And then something that we consider the accommodation of last resort, we call it the reassignment to a vacant position, okay, reassigning that individual to a position that they are qualified to do, okay. Some actions that are not accommodations, right? Lowering the production standard. The whole point of a reasonable accommodation is for that individual to meet the expectations, right, of the company. Violation of rules or conduct. These are kind of behavioral rules. So, if accommodating someone's outrageous or inappropriate behavior, that's not something that needs to be accommodated. Removing an essential function of the job. Again, the point of a reasonable accommodation is for that the person can do the essential functions of the job. So that's not necessary. Monitoring the use of medication. That is up to the employee, not the company. Providing any personal items. The company would not have to do that as a reasonable accommodation. Changing a person's supervisor. Again, maybe changing the supervisory method, okay, but not changing that person's supervisor. And then importantly, any action that results in an undue hardship. Okay, so let's get into undue hardship if there are no questions about accommodations. An undue hardship, all right, so an employer must, if there's an accommodation, an employer must provide that accommodation to that employee. If there is no accommodation, so if there's just not an accommodation for that individual to perform the essential functions of the job, then that person isn't qualified. Okay, so that's one thing that could happen. The other thing that could happen is that there is an accommodation for that individual, but the employer says there's an accommodation, but I cannot provide that accommodation because it's going to be an undue hardship for the company. Okay, So we call that an affirmative defense. There is an accommodation for that individual, but the company cannot provide that accommodation because it's going to be a significant difficulty or expense to be able to provide that accommodation. Okay. Now the key word here is significant. Okay. And so you really want to make sure that if you're an employer and you're using this affirmative defense saying, yeah, we have an accommodation, but we can't provide it because significant difficulty or expense, you really need to be able to show the significant difficulty, okay, or the expense. And, if you're a mom and pop, that difficulty or expense may be easier to show than a company that has, locations all around the country. Okay, it's a very large company. Okay, the expense and difficulty in providing reasonable accommodations is different. All right, so look at the nature and the cost of that of accommodation. It has to be significant. It can't just be something that is small. Okay, and honestly, I think the last time I checked, the most accommodations can be had for under $300. I think you may be able to provide. I think you might have some better information on that, but most accommodations can be had and provided to employees for less than $300. Okay, so that's hardly going to get to the significant difficulty part, even for a small employer. All right, if it's going to change the very nature of the work that is done, okay, or it's going to impact the employer's operations, these are big things, by the way, then maybe the employer can say, well, this is going to be an undue hardship. And that's the reason why we can't provide this accommodation for this individual. Okay, so keep that in mind. If you're an employer, keep that in mind for undue hardship. If you're an advocacy group, keep that in mind as well. If there's an accommodation out there, the employer is entitled, was required, to give that to that person with a disability unless there's an undue hardship. But the employer has to be able to show that there's an undue hardship.
Hi, Brien.
Yeah.
This is Bonnie Bomer from Indiana Disability Rights. The site is having some technical difficulties, so she asked me to kind of fill in. You do have a couple of questions.
Okay.
The person wants to know, Anne wants to know if the EEOC covers all employers.
Okay, great. That's an excellent question. I didn't really get into that. Most employers are going to be covered by the Equal Employment Opportunity Commission. If you're under 15 employers, so if you have less than 15 employers, you probably will not be covered under for the EEOC. For most of our laws, equal pay is a little bit different. But that doesn't mean that you wouldn't have covered. There's lots of FEPA partners. They're the Fair Employment Practice Agencies that we have in Indiana. I think there's some representatives from our FEPAs here today, I believe, and they may be able to cover smaller employers. So if you're a smaller employer, less than 15 employees, for most of our laws, it's less than 20 for the Americans with, or the Age and Employment Act. So age is a little bit different, okay, but everything else would be 15. So if you're a small employee, we would not be able. Employer, we would not cover you. And then also independent contractor. So if you're an independent contractor, we would not have jurisdiction. But that's a whole separate matter.
And another question was, and I think you answered this, what if the employer says they cannot afford to provide a reasonable accommodation?
We hear this all the time, right? I mean, this is often what we hear from the EEOC. You as an advocacy group or employee or even a business may hear this as well. Like, hey, we can't afford this particular accommodation. What I would really do with that is, it may be true. It may absolutely be true. And there is nothing that I would be able to say is like, once you get past this dollar amount, it's going to be significant. It's a significant expense. It's going to be different for each company, right? Because each company has a different, profit margins and everything. So they're going to be valued at differently. So you really do have to look at it on an individual basis, but it really is up to the company to show this is going to be a significant burden on us. This is going to be a significant expense to provide this accommodation. And like I said, I think really if a company is saying that, I know that I always do, and certainly the investigators, if a company is saying that and providing that, we're going to check it out. We're not just going to take the company at its word. So companies, you should be aware of that. We're going to look into it as well. Is that accommodation going to actually be that much money or be that much expense? Or is there another accommodation out there that could do the same thing, but be less expensive? There's one example, it could be like, hey, this person, because of their disability, they need to be able to sit down when they're doing their particular job. And so the person, comes and says, hey, I found this, $8,000 massage chair that would be just perfect for me to have. The company can say, no, actually, all we need, that's required for the essential functions is for you to be able to sit. And so we have this stool that you can sit on that's maybe only, $50 or $100, and that's going to be the reasonable accommodation. But it works the other way, right? So maybe the company says, oh, well, that reasonable accommodation, we're going to have to rearrange our entire, manufacturing line, and we're going to have to, it's going to cost the company, thousands of dollars to restructure. But there could actually be a disability that's an accommodation that is much cheaper that can be used instead. And so there's this back and forth, this dialogue. It's sometimes called the interactive process that you should be having conversations with the employer and saying, well, let's, if it's not this disability, what about, or this accommodation, maybe this one will work, or maybe it's not this particular tool, maybe we can use this tool and it'll have the same function. I hope that helped.
And then finally, the last question I see here is, having a job coach or an employment consultant present during interviews considered reasonable accommodation?
I think it would be. Yeah, I think it would be. I mean, I don't see why it wouldn't. But again, it's something that's going to be individual, right? So accommodations are individual to that person's need. So if that is going to allow the person, to be able to perform the essential functions of the job duty or allow them to apply for the job, then yeah, that would be something that I think you would certainly consider.
Great, thank you.
But Brien, I'm back.
Okay.
I apologize for that. I was having technical issues, but I don't know if they have the opportunity to ask you what is the statute of limitation to file a complaint with the EEOC in Indiana, 180 or 300?
So in Indiana, it's going to be 300 days.
Okay.
So 300 days is the statute of limitations. If something occurs, you want to be able to file a charge within that 300 days.
Okay, thank you.
Thank you. So we're going to talk just a bit, because I know I don't want to spend, I want to respect your time. I'm going to quick talk a little bit about disability-related medical questions, because I think this comes up quite a bit, and this may be very helpful to our advocacy groups out there and our individuals out there. So pre-offer, so this is in the application process. There should be no questions that require, no questions that are asked that may elicit medical information, and there should be no medical examinations that are required of you, okay? Post-offer, meaning the job has been offered, okay, but before you start, they're going to have you do a medical exam. That's okay. They can ask you medical questions at that time. They can have you go through a medical exam, as long as they do it for everybody in that particular job position. So they're not singling you out, okay, but they're just saying, hey, everybody that comes into this position, they have to go through a medical exam. That's perfectly fine, as long as it's post-offer. They've offered you the job already, okay? And then current employees should not be having to do any kind of medical exams or ask for medical information unless it is job-related and consistent with business necessity. And so what does that necessarily mean? Well, if you're currently working at the job, okay, maybe you need an accommodation. So you tell your employer, hey, I need an accommodation. Well, then employer can then ask for medical information. That's fine. They may need some medical information. They're not health experts, right? We don't expect them to be doctors. And so you want to make sure that you're giving them information and that they're getting information that is accurate and correct about your limitations of a major life activity. There may be some impairments that are hidden, right, that are not obvious. And so maybe that you may be able to, you can provide information to that employer because they're hidden disabilities. They may not be able to see those disabilities and know what those disabilities are. And oftentimes it can happen that an employer can ask you questions if they have a belief based on objective evidence that there's a issue with you performing an essential function, or that you may pose a direct threat. We're not going to get into direct threat, but if there's an issue or problem with the way that you're performing an essential function of the job because of a disability or a medical condition, then they can ask you medical questions, or maybe have you go for an exam. Okay, it could be that they're not, the need for an accommodation isn't obvious, right? So, all right, so we need some information to see what kind of accommodation that you may need. That's fine that an employer asks that. We just need to make sure that that information or that exam is tailored specifically to that job. Okay, and so it's not just a general, hey, fitness test that's making you do all sorts of things, but that the test itself or the exam and the questions are tailored towards that specific job related issue. Okay, and that's really important. And another thing people always ask me about is drug tests or testing for illegal medication. That is not subjected to the ADA's restriction on medical exams. They don't consider that a medical exam. If you're currently using illegal drugs or abusing legal medication, that would not be covered under the Americans with Disabilities Act. But if you're recovering, if you're no longer using, if you're recovering, you would be covered under the Americans with Disabilities Act. Okay, just so something to keep in mind. And then the last things I'd like to talk about is just this hiring process, because I think that can be tricky as well, especially if I'm an individual with a disability, or if I'm an advocacy group and I'm helping people with disabilities. It's important that we understand what are some best practices. Okay, so when you're in the job interview, or when you're having a job interview, the employer should be asking you, right? They should be asking you questions about the particular job itself, right? And you should get an idea, and you can ask about the essential functions of the job. What are the essential functions of the job that'll be necessary for you in this particular position, just to see if you are qualified. The job interviewers should be asking questions that look for your job qualifications. They should be looking for the best qualified individual for that particular job. Okay, so the questions that you should be receiving or listening to and answering should be questions related to your qualifications. Okay. If you're an employer, you should definitely make sure that everybody in the hiring process is aware of the reasonable accommodation, the need to provide a reasonable accommodation. I can't tell you how many times the issue becomes, the person at the front desk wasn't aware of reasonable accommodations, and an individual with a disability comes in, once a application, and for whatever reason needs a reasonable accommodation to complete that application, and the front desk person says, I don't know what you're talking about, we can't do that, sorry, you can't apply here. That's a huge problem. All right, so we want to make sure that if you're an employer, everybody in that hiring process knows about reasonable accommodations and the need for a reasonable accommodation. And you should be, if you're an employer, be able to articulate the reason why you did not select an individual. And that reason should be a non-discriminatory reason. Okay. Again, some best practices for employers is that have a diverse hiring panel. Okay. One of the things that often we find is that if there's just one person doing the interviewing, or maybe everybody on the interview panel looks the same, you can get into this group think. There are some biases that can come out. And so if you have a diverse hiring panel, you get different ideas, different ways of looking at the applicant, and that can be very, very good for finding the best qualified person. And again, you should make sure that you are looking for the best qualified individual. All right. I always talk about community partnerships, because I think they're so important for employers and for, of course, employees as well. Knowing who your advocacy groups are in the community, building relationships with them. If you're an employer, that's a really great connection to have, because if something comes up within your organization, you have a contact that you can get a hold of, and maybe they will be able to provide some answers for you, which is great. It's a way to really benefits everybody. So, it's a good way to overcome barriers in hiring, particularly, and something that I think that always makes a good relationship. And really, the last thing I want to kind of end on here today, before I get any other questions, we have some time left for questions, is confidentiality. Information should be kept confidential. So any information that you get during the reasonable accommodation process or any medical information should be kept confidential in separate files. And that's important, certainly for an employer to know, and for an individual to know too, that their information is not getting out to just anybody. It's only going to be the people at the company, usually management, that needs to know about either your accommodation or a medical issue. It could be that there are some, first aid workers or safety personnel that need to know in case there's a problem in the work environment, or if you're in a plant, if there's a safety procedure protocol, they may need to know information about your disability. But again, that's going to be the only people that need to know. So I'm going to now kind of end this slideshow here. And I would like to open it up to questions. If anybody has any questions about the EEOC or the ADA, reasonable accommodations, or any other topic that I didn't touch on today, feel free to ask that question. I will say also, feel free to contact me. My email is brian.shoemaker@eeoc.gov. It's Brien spelled BRIEN shoemaker@eeoc.gov. Feel free to email me questions, and I will certainly be able to hopefully answer them, or at least point you in the right direction. And I'll be more than happy to at any time take your questions. So does anyone have any questions now that they would like to ask? You can put it in the chat. That's fine. Or if, we only have a couple minutes left, if you just want to unmute, that's fine too. And you can ask me the question.
We have one question here on the chat, and it is, what does a person that has a service dog can do if the person goes to an interview and the person that is interviewing them begin to ask questions about the dog?
Well, so that can, service animals, that can get a little bit tricky, but I would say that if they're not asking inappropriate questions about the dog, I think that it's fine. If you have something, if you have an obvious disability, and the employer can see that you have a disability, and you have that service animal, that would be a need that would kind of show that you have you're probably substantially limited in a major life activity. And they may be able to ask questions about that, since it's about how you might perform certain functions of the job. They might be able to say, one of the essential functions of the job is this. And so they could ask, well, are you able to do that? Okay, can you do that with or without a reasonable accommodation? And so those are the types of things that certainly they can ask about if it's obvious. Okay, and having a service dog there would show that there is more than likely a disability involved. What I would have that person do, whoever asked that, I don't know whoever asked that question, but go ahead and shoot me an email, and I want to get a little bit more specific information for you about service animals, and that way you're more prepared if that happens to you.
Thank you, Brian. Any new question? Okay, we have a new question, Brian. Have you seen an increase in companies requiring people to back to work in the office, and people not wanting to do that because of the risk of exposure to COVID?
I personally have not seen that. What I would say is that for employers in particular, but even for employees as well, going back to the office can cause all sorts of new issues to come up. And there may have been some things that happened while you were away from the office that now you may need a disability for now that you're back in the office. Okay. Or excuse me, a reasonable accommodation for now that you're back in the office. So it's very important that that employers still go through the accommodation process when people are coming back to work. If there's an if someone comes back to work and they're requesting an accommodation for whatever reason, the employer should still go through that process. Okay, they should say to themselves, the question that needs to be asked is, can I accommodate this individual? Okay, so that is what they need to go through. And if you're an individual and you're returning back to work and you need an accommodation now, maybe you didn't before, but now you do, that's fine. Ask for the accommodation. All right, that's the process that we need to go through.
Well, Brien, we are having several more questions on the chat, but we are 1 minute to go. Can you please repeat your email? They are asking for your email.
Sure. So my email is brien.shoemaker at eeoc.gov. That's BRIEN.SHOEMAKER at eeoc.gov. And feel free to ask me any questions that you have, and I will get back to you as soon as I can or point you in the right direction. And again, the person with the service animal dog, please do email me because I do have some specific information I'd like to give to you.
Okay, well, to be respectful with the time of everyone, we're gonna call it for the day, but we are very happy and we are conserving these questions. We will make sure that we send them to Brien. And you can get more information about the new webinars that we're gonna have this month at www.worktoinclude.org. And thank you very much. And thank you, Brien, for your time and participation this morning.
Thank you.
Thank you. Bye.